Hello, everybody, and welcome back, all you entrepreneurs who like to listen to Radio Entrepreneurs. We continue to stream stories of business, leadership, and how people are adapting to this ever-changing economy. Every week, we like to check in with Mark Furman, director and shareholder at Tarlow, Hart Rodgers, for the segment Entrepreneurship and the Law. Welcome back, Mark.
Hello, Jeffrey. Great to see you again.
You too, Mark. So what's hot on the ticker tape today?
Well, Jeff, business owners have a million things that they have to deal with, and it's easy to take some shortcuts. But one area that I want them to really think about are the employment laws as they employ people. Here in Massachusetts, we have extremely strict laws. So let me give you an example. If funds are a little low and you're a day late paying wages, what's the result? So, maybe a day's worth of interest, you might say. Wrong. How about 3 times the wages plus attorney's fees?
Wow.
Wages are due and payable when due, and the law sets when they must be paid. And it's a firm deadline. So that's just one example of hundreds of regulations and laws that deal with the employment relationship. And a lot of them provide for, multiple damages if you make a mistake. So, in business, there's always the juggle going on. And, we're entering a potential, hopefully not, potential recession. People are talking about that as a possibility. And there's usually a relationship between a recession, decreased profits, decreased revenues, and it poses special challenges. But don't assume you can just, don't pay your employees today. You'll pay them next week or the week after. So there are also very strict laws relating to overtime.
Right.
And who gets paid overtime and who's not entitled to be paid overtime, who's in effect an exempt employee. But don't assume because you think they're exempt and you give them a salary that they're not entitled to overtime. It's a whole analysis that needs to be made. And once again, if you're not paying overtime, you're not paying wages, overtime or wages. And so again, we're talking about severe penalties for non-compliance.
Well, this could be quite interesting, and I'll pick one industry in particular. Maybe our largest employer in our state is the restaurant industry, where there's short of staff, and I assume they're paying a lot of overtime. Cost of goods are going way up. I don't know if traffic is what it once was. So restaurants are still being squeezed, and this might be an area where an inexperienced restaurant entrepreneur, for example, may think that they have the ability to cash flow payroll and get themselves in trouble, correct?
Yeah, right. You can't defer payroll. You can't defer. And, there are also rules around how tips are treated. Who's entitled to tips that are left? Short answer is the house is not entitled to any portion of a tip that is left. And there are just many areas which are really traps for the unwary. You send out a offer letter. We're pleased to offer you a position as a salesperson for XYZ company at a salary of $50,000, $60,000, $70,000 a year, whatever it is. what is that saying about your ability to terminate the employee for no reason or for any reason? In general, you want to make sure that your offer letters make clear that employees are employees at will, that they can leave for no reason or any reason, and the company can terminate the employee for no reason or for any reason. That doesn't mean that the company necessarily can, even if it says that, because there's a whole body of laws that limit employer conduct. You can't terminate for retaliation, for bringing up something protected. You can't engage in sex discrimination, race discrimination, many other types of discrimination. So even though your agreement says the person's an employee at will and can be terminated for no reason at any time, consult with a lawyer before you pull the trigger. Make sure they know the facts. And also, one of my pet peeves, look into employment practices liability insurance. It's one of the best insurance values, I think, for business owners. And if you end up getting sued by a employee, it comes in really handy, because sometimes the cost of the fight is more expensive than the actual result. That's not always the case, but sometimes it is. It's very easy to file an employment claim. So just a potpourri of thoughts for employers in the employment context.
I'm not questioning the law. I just think it's very hard. Everybody has a bias for different things that we learn about. And, it's very hard to prove, I think, discrimination unless you have some blatant, witnessed effect. I mean, it just seems to me to be very hard, because I see bias all the time. Bias around work habits, about you say all the things you listed, but gender differences, gender expectations, people not understanding when people have families. It's very hard to put your finger on that. Wouldn't you agree with that? I mean, you really have to have a lot of evidence.
Well, if there's nothing in electronic writing, or I've seen people write things on reports that were almost per se discriminatory. I've had those cases, but people say in texts and emails things that they would never put in a letter. It's just, it can be rapid fire. And when people are angry, they may text or email something that they regret. So that tends to be where the action is in these cases, is the electronic discovery. And there is a duty to preserve all that. And so sometimes things come out. In the absence of that, though, the law, there's this very complicated legal standard that's been adopted that maybe we can talk about next week, for how discrimination cases get litigated, who has the burden of proof, and how it shifts back and forth. And because there certainly has been an explosion of employment claims over the last few decades. It's an area that companies need to, be mindful of, and more cautious about. And I think entities that have, been sued, get it. But when you haven't been sued, I think it's hard for business owners sometimes to realize how much of a problem these cases can be. Because in the discrimination area, for example, it is possible to recover not only economic damages, but emotional distress damages. So somebody could view that as a bit of a lottery ticket. And there have been some large emotional distress awards in employment discrimination cases. So I think you need to take the employment area as a serious area with a great deal of risk. Your employees are, they're the heart and soul of your business, but it is a trap for the unwary legally, and the playing field is designed to protect employee rights. The legislature hasn't written these statutes to protect employer rights.
I understand
So be mindful of that.
We've been speaking with Mark Furman, a director shareholder at Tarlow, Hart Rodgers. This is our segment, Entrepreneurship and the Law. Clearly, entrepreneurs have to understand the parameters of how they need to operate so that they can be successful and not go afoul of the law. So if someone wants to understand that better, Mark, how would they find you?
Best way to reach me is by email, mfurman, FURMAN, at tbhr-law.com.
Great. I want to thank you for being on the show today, and we'll see you again next week, Mark, on Entrepreneurship and the Law.